that will also produce a valid revocation. Okay. Canceling. How do you revoke a will by canceling? By crossing out the lines. How does cancellation differ from obliteration? In obliteration, the words can no longer be read. Binubura. Okay. In cancellation, they're simply crossed out. Whatever kind of line you may use, crisscrosses, spirals, whatever. As a matter of fact, one of the simplest ways of revoking a will through cancellation is by crossing out, cancelling the signature of the testator at the end of the will. If you are the testator and with intent to revoke your will, you cancel your signature at the end of the will. In a very real sense, you strike at the heart of the will. That will operate to revoke the entire will. Okay? Right. So, burning, tearing, cancelling, obliterating. In connection with revocation, it is entirely possible that the testator may have made several copies of his will. Okay? So, which is usually the case. Testator will retain one copy. He will entrust the other copies to his friends or to his lawyer for safekeeping. If he wants to revoke his will, does he have to retrieve all copies? The answer is no. He can simply burn or tear the copy which he has. That will produce a revocation of his will. He does not have to retrieve all of the existing copies of the will. Okay. Supposing that the testator changes his mind while revoking his will. Testator has instituted you as a will, as heir to the bulk of his estate, and one time you had a chat with the testator. You visited him, and over some coffee you started discussing various things. Okay? At a certain point, you disagreed on something quite trivial. Pinagtarulan lang nyo kung mas masarap kainin ng isda kung may kasamang kamatis. Sabi ng testator, masarap yung may kamatis. Sabi mo, mas masarap kung may sibuyas. Yun lang. That started the whole thing. Before you knew it, you were both shouting at each other. Okay? And at a certain point, that napikon ang testator, he got his will from his drawer, and he waved it in front of you, and he said, you are not going to inherit a single centavo from me. Okay? He tore the will once. After tearing the will, he threw the pieces to the floor. And he tells you, oh, say mo. At that point, you realize what had happened. And so you knelt down in front of the testator. You told him, I'm sorry. I take back everything I said. Tama ka na, mas masarap ang kamatis. Please do not revoke your will. So the testator was mollified and he reconsidered. O sabi niya, sige, pulutin mo yung yung will, and let's use scotch tape. I-paste natin together. Can that will still be allowed? The answer is no. Why? Because when the testator changed his mind, the act was already subjectively complete. Paano na natin nasabi na it was subjectively complete? His act of throwing the will to the floor simply shows that insofar as he is concerned, consummatum est, natapos na yan. It has already been revoked, kaya nga tinapon na niya. He did not intend to go any further. It's a completed act. If he changes his mind at that point, it's too late. Okay? You cannot restore validity to a will which has already been revoked by tearing, by simply pasting the pieces together. Okay? Usually, at this point, sinasabi ko, you remember si Humpty Dumpty. Pero natatakot na ako. Minsan nagbigay ako ng examen sa undergraduate. Tapos sinagot sa akin, according to the Humpty Dumpty rule. There is no such rule in law. Example lang yan para matandaan. Ha? That you cannot restore validity to a will which has already been torn, revoked by tearing, by simply pasting the pieces together. Sabi ko, just like Humpty Dumpty, di ba? All of the king's horses, all of the king's men cannot put back Humpty Dumpty together again. But supposing that while the testator was in the process of revoking his will, nag-away kayong ganon, so you'll not inherit, blah, blah, blah. He tore the will once, tapos twice, patatlong beses pa. He was about to tear it a fourth time. When you pleaded to him, please, I'm sorry, stop. And he stops. And then, you ask for his forgiveness, and he said, okay, let's paste the pieces together. Can that will still be allowed? Assuming those facts can be proved. The answer is yes. Because the act was not yet subjectively complete when the testator changed his mind. Why do we say that it was not yet subjectively complete? Even from his point of view, it was not yet a completed act. He intended to tear it a fourth time, but he was prevailed upon not to do so. So the act was not yet subjectively complete. Therefore, if the testator stops, changes his mind, there is as yet no valid revocation. Okay. Another rule we have to remember in connection with revocation is the doctrine of dependent relative revocation. It has already been asked in the bar. It might be asked again. What is this doctrine? If the testator revokes a will with the present intention of making a new one immediately and as a substitute, and he is unable to make the new will, or if he is able to make the new will, the same fails to take effect for any reason or cause, it is presumed in the absence of evidence to the contrary that the testator would have preferred his old will to intestacy. In other words, when the testator revokes his will under this doctrine, he does so conditionally. Ano ang condition? That a new will be effective. So kung hindi siya nakagawa ng bagong will, or if the new will fails to take effect, then it is presumed he would rather die with his old will than to die intestate. Okay. The best illustration, of course, would be the case of Molo versus Molo. It's an old case. Okay. But up to now, that's still the best illustration of this doctrine. Here was a man. He made a first will in 1918. Okay? 1918. In that will, he gave practically the entire estate to his wife. Okay. In 1939, he made another will. In this second will, he expressly revoked his earlier 1918 will. So, I revoke my 1918 will. And then again, he gave, ganon naman, just like before, he gave the bulk of his estate to his wife. Okay. Namatay. So, pagkamatay niya, the wife presented the second will, yung 1939 will, for probate. Unfortunately, it was disallowed by the probate court. Reason? It failed to comply with the formalities prescribed by law. Okay. So, ang ginawa ng widow, ay hindi pala pwede yung 1939 will, balik sa husgado. O ito na lang ang i-probate natin, yung 1918 will. She could not, however, present the original copy of the 1918 will. The best that she could produce was a duplicate of that 1918 will. So the oppositors were saying, Oh, nasaan ang original niyan? Kaya hindi mo maipresenta ang original niyan. It's because your husband already destroyed the original copy of that 1918 will. He revoked that by destroying the original copy. Kaya hindi mo na maipresenta ngayon ang original. Okay, nakarating Supreme Court. Pagdating Supreme Court, ang sabi ng Supreme Court, even assuming that that is true, sabihin na natin totoo yun, that the husband after he made his 1939 will, nung nakagawa na siya ng second will, sinunog na niya yung original nung 1918 will with intent to revoke the 1918 will. Nonetheless, under the doctrine of dependent relative revocation, it should be understood, it is presumed that the revocation of the 1918 will was conditional in the sense that it was conditioned upon the effectivity of the 1939 will. Since the 1939 will failed to take effect, it is presumed that the husband would have preferred his old 1918 will to intestacy. That is the doctrine of dependent relative revocation. Another point which I want you to remember in connection with revocation is this. Sometimes revocation may be presumed, depending sa circumstances. For example, there is evidence to the effect, okay, that the will was in the possession of the testator. He is the one in possession of the will. After the death of the testator, the will is found among his possessions, among his effects, in a tattered and torn condition. The presumption is that the testator revoked his will. Or, if after his death, the will could not be found, and the evidence is clear that he was the one in possession of it, it may be presumed that the testator revoked his will. You also remember the provisions of Article 833. A revocation based on a false or illegal cause is not valid, is void. The important thing I want you to remember, however, is that before you can invoke Article 833, it is necessary that the cause for the revocation must be stated in the will. If the testator simply revokes a will, even assuming that the cause for the revocation is false or illegal, but he did not state the cause for the revocation in the will itself, there will be no basis for any invocation of Article 833.